You are listening to a series of 10 podcasts on the judicial branch of the United States government, presented by Citizen U. Episode 3. Discuss the difference between district, appellate, and Supreme Courts. Explain the difference between appellate and original jurisdiction. The American judiciary is characterized as a dual court system. There are national courts and state courts. This is due to federalism. Our emphasis here will be the national courts. There are also two types of law in this country: criminal law and civil law. Criminal law is law between the state and an individual. An example of criminal law would be an individual breaking the law by robbing a bank. Civil law is between two people. An example of civil law would be one person sues another person for violating a contract. It can be said that we live in a litigious society. We litigate, take people to court, for just about everything. There are 94 district courts in the national or federal judiciary. District courts are the lowest trial courts. District courts have what is called original jurisdiction. They hear a case for the first time. It should be noted that most civil and criminal cases do not even make it to court. Most cases in our judicial system end in a settlement or plea bargain. A plea bargain is a deal made between the plaintiff and the defendant in order to bypass the need for a formal trial. In civil suits, this involves an adequate financial settlement. In criminal cases, this usually involves pleading guilty to a lesser charge. In addition, there are 12 appellate courts. Appellate courts, often called circuit courts, hear federal appeals. If you lose in the district courts, you can ask a higher court, an appellate court, to consider whether or not your trial followed the law correctly. If you lose in an appellate court, you can appeal to the highest court in the land, the United States Supreme Court. The only court mandated in the Constitution is the U.S. Supreme Court. The U.S. Congress has the authority to create courts and to determine the number of justices on the Supreme Court. In the U.S. Supreme Court, like all appellate courts, it is not a trial determining guilt or innocence. At stake is the constitutionality of law. You are listening to a series of 10 podcasts on the judicial branch of the United States government, presented by Citizen U.